From Florida's Space Coast, this is Your Career.
Welcome to Your Career. I'm Debbie Featherston, your host, and with me is Ed Kinberg, who is partner of Wiederman Malik. Thank you for being here.
Well, it's a pleasure, Debbie.
This is a subject that I've been wanting to discuss with someone like yourself, Ed, for a long time. And legal issues in the entrepreneur. There are more people that I've helped to start businesses and really encourage them to identify an attorney up front. So I don't want to jump too much into that, but before we get into the real subject and look at the heart of this, I would love to have you tell me a little bit about your background and your law practice and your experience.
20 years of practice with the United States Army as a judge advocate and attorney. And the last half of that practice was in contract law. Part of that is several years as a contract litigator representing the Army in disputes around the world. Part of that was as a deputy in Europe and also a procurement fraud advisor. And then finally just doing a senior attorney doing contract work in the Aviation Troop Support Command for the Army. So doing the last 10 years or so in my military career, when I was doing that kind of stuff, I learned a lot about what kind of contract problems and companies run into. And you could see when you went to a company to discuss what the issues were and investigate the claim, you could see that many times there were disputes between the employees and the administrators. And you kind of wondered, well, how did we get to this point where they have a claim and they aren't having a consensus as to how to resolve the claim? I'm getting different viewpoints from different people. So that interested me in entrepreneurship. And of course, in the military, you get tons of training and leadership. You go to class probably 2 weeks a year as some kind of training. So when I got out, I was invited by a former Armor Buddy judge, who's now a judge, David Dugan, and asked to join his practice. And I did that, and we were doing some stuff, and I was going to build up a government contracts practice because that was my experience. And he got the judicial itch and ran for election, which, of course, was a great thing for him. But then that left me out there and thinking, oh, great, I was relying on his knowledge of the community and expertise, which he gave me quite a bit of, and he's continued to support me over the years, but he's a judge now, he can't say much.
Right.
Over the years, I had a general business practice where we did not just the government contracts and construction that are my specialty areas, but general corporate business advice with a lot of startup businesses.
I'm curious, what specifically was it about the field of law that you found attractive or appealing?
That's a really difficult question because I wanted to go to law school since I was probably in junior high school.
Oh, wow.
And I couldn't say what specifically drew me to that, but I developed my college curriculum based on the concept of I'm going to law school.
Yeah.
And I did go to law school, and I focused also, I wanted to be in the military, so I really kind of focused on being a military lawyer. I don't think at any time I realized how long or difficult a road that would be and what the odds were against you in achieving that goal. It's just, I said, I think it'd be cool to be a military lawyer, travel all over the world, and do cool things. And that's the best thing. And at the time, I didn't realize in the military also, as a large law firm, and we have the same diversity of practice with the addition of military law and regulation, law of war, specialty subjects that any big commercial firm would have. So I practiced in a lot of areas. I've done legal assistance, I've done claims, did medical malpractice, prosecuted and defended criminal cases. So huge array of experience in the military. It was really great growing experience for me.
But no single event that was the trigger that went, this is why I have to practice.
Maybe Raymond Burr when I was a kid, Ironsides, I don't know. That's going pretty far back in the past. So,
but I know the show. So starting with the startup operations, what are some common issues that a person who's thinking about starting a business, who's early in the business, but it's not fully formed, need to consider? What are some of those common issues?
Well, to me, and I'm not talking about the management, accounting, leadership aspects of the business. I'm just looking at the legal side because there's lots of other stuff.
That's all I want to look at.
The business, that's lots of other stuff that comes before you actually start your business. And we're not there today.
Right.
Today we're looking at what would be the most effective form for me to operate my business in. If my business has a lawsuit against it, a personal injury, a business lawsuit, am I going to have to pay out of my own personal pocket? That's the number one issue, limited liability. And you avoid that liability by picking any one of a number of different entities. A lot of people start off as a business as a sole proprietor.
Right.
Not recommended. A sole proprietor is liable for anything that happens. Now, So if you get sued for a business problem, you're going to be personally responsible, and to the extent your house is available in Florida, which it's not generally because of homestead, but your personal assets, unprotected assets, will be open to anybody that files a lawsuit. So a sole proprietorship is not a recommended entity. The next one up the line is a general partnership. Now, there's all kinds of different partnerships, and there's limited partnerships that will give you legal protection, but those are kind of too complex to go into. And a general partnership is the same thing as a sole proprietorship, except you're also responsible for any problems caused by your partner.
Oh.
So it's what's called joint and several liability. So if you and I were to go into business together and we want to do a general partnership, no corporation, no limited liability company, no, we don't register under the partnerships law, limited liability partnership rules of Florida, then you could go out and have a car accident in the course of duty. You're driving somewhere to do a show, and I would be liable for you. And so that could drive both of us under. It's not recommended. The next two levels, and there are technical differences between the two, but they both give you the limited liability, is either a corporation or a limited liability company. Older lawyers like myself, because we're used to corporations, lean toward corporations, but they do have slightly more formality than a limited liability company. But the nice thing is in a corporation and in a limited liability company that has more than one member, if you have more than only one member, it's a different issue. Then you do have limited liability, and they may be able to take your dividend interest in your stock, but they can't take your stock unless it's a single member owned LLC. So it gives you a lot of protection if the company gets sued. So I always recommend one of those two formats. And then once you select your format, at that point, I recommend you at least invest in an hour of talking with a business attorney. If you want to save money and go online and do stuff, that's kind of 50%, 60% okay. Because online, there's a lot of good information and there's a lot of wrong information. So you can go online and you learn about these business formations, about how you build up relationships between others that are going to be owners of your business. But then you go to a lawyer and say, can I do this? Is this smart? And is it allowed in Florida? Because not everything you get online, even though it may be legitimate in some other state, may not be legitimate in Florida.
That's a great point.
So I do think you do need to consult an attorney. But actually starting up in a corporation or an LLC, you can go online at sunbiz.org and click on the form to set up a corporation and do it. But that's not enough. You also have to have a corporate book or an LLC book, and you have to show that you've got your federal employment identification number. You either have workers' compensation or exemptions, and then for corporations, you have to have your annual meeting every year. And your annual meeting, well, let me back up a little bit. You don't have to have annual meetings for LLCs unless you have an agreement that says you do. And that's really the most, I shouldn't say the most significant. That's a difference in paperwork. But both of them have to be renewed annually with the state. And failure to renew it annually with the state means that they will administratively dissolve your corporation, and then you become personally responsible for the obligation. Could become personally responsible. You know, in the legal business, we got to use the word could a lot. Because, you know, I say this to all my clients, anybody can sue anybody for anything, Debbie. So I can't say nobody's going to sue you. But I can say the odds of them succeeding are very, very slim against you personally if you're in the right format and you maintain your books and records correctly. So what does that mean, maintaining your books and records correctly? Having a book, and you can buy these online. You could just look up Florida incorporation books or Florida LLC books. You'll find
but your attorney would even put one together for you, though.
And
because that's how that's what I did. I incorporated and had the attorney handle all that here. So I got a book and details.
And it had a metal seal in it. And we buy those books from the same places you can buy those books. But we make sure the books get completed. A lot of people do buy those books, and they come in to see me when they get sued 4, 5, 8 years after they're in business, and there's no annual minutes. There's nothing in there. And that's not good. That's not good. I'll never forget our first seal, though, because our book hadn't come in yet. And so we had to go to the bank and open a credit line, and they wanted a seal, so we drew a little smiley face. The bank accepted that as our seal. So to my prior firm, that was our official corporate seal, was a little smiley face.
Oh, that's great.
It was a seal. So you need to do that. You need to keep your corporate records in order. You need to keep a record of who your shareholders are in the terms of a corporation or who your members are in an LLC. If you have more than one member, you should have, I don't want to say should have, you must have a membership agreement or in a corporation, an operating agreement that says what your agreeing to do by contract. Keep stuff confidential. If you leave the business, not compete with it. Don't talk bad about the business. How you're going to deal with it if you want to leave the business. Stuff like that would all be
Some kind of a buy-sell agreement. Is that maybe if you're talking about a corporation specifically, or
a buy-sell agreement for either an LLC or a corporation would be part of your operating agreement or your membership agreement, and that would explain how you're going to do all those things. And the one thing I always encourage people never to do, it's not good grammar, I suppose, I encourage people not to do, is don't start a 50-50 business.
Oh.
Because if you start a 50-50 business and you get in a deadlock, the only solution that can happen if you can't break that deadlock is dissolution of the corporation. So it's a dangerous thing to do. One person should be in control of it. I know it's not always a practical thing, and that's a difference between an LLC and a corporation. And this is kind of a complicated accounting thing. But in a corporation, if you own 10% of the corporation, and if the corporation ever issues dividends, you get 10%. So if you and I are 90-10, I can't take money for myself out of the firm without looking at the total amount and saying, okay, I get 90%, Debbie gets 10%. And we see a lot of businesses that actually do that. It's wrong. In an LLC, you can have distributions that are not the same as your percentage of ownership. So that's a big difference. So you could have a minority owner, so whoever is the real creative force can still own the majority of the business. Whoever's bringing the funds to the table or some expertise to the table may be getting more than half the profits, dividends. So you can do that kind of stuff. So that's important to keep in mind.
Yeah, that's very important. So what are some other common issues? We've got formation, buy-sell, anything else that comes to mind? That
Non-compete, confidentiality agreements, all that kind of stuff is really a package of stuff that most attorneys will create for you when you do it.
Right.
But then you have to have you have to make sure you pay only your business bills from your business account. You don't pay your home mortgage. You don't pay, if you pay your car payment, you figure out a way to show it as a business expense.
Certainly.
Because when you get into a lawsuit, somebody has to be able to look at those books and say, hey, these are two separately existing things. Because a corporation is a person from legal purposes.
Right.
And so you're one person, I'm another person, and we need to keep our business separate so that I don't become responsible for your problems.
Yeah.
And I'm sorry, Debbie, I like you, but I don't want to be responsible for your problems.
That is very smart. Have no problem with that. So what about, entrepreneurs? They always think about their brand. They get their logo out there. What other protections do they need to have in place before they start marketing their business and using the logo or company name, things like that?
I'm glad you brought that up, Debbie, because we do need to step out. We've talked about corporate structure fairly thoroughly. And of course, if any of your viewers want more information, they can go to our firm, our website. They can call any lawyer.
Oh, sure.
But trademark, copyright, and patents all fall into the field of intellectual property. Intellectual property is the heart and soul of any business, because your goal as a business is to come up with a name and a logo that represents high-quality services or high-quality products, whatever you're doing, so that people, and like your career show.
Yeah.
That may or may not be, I don't know if legally if it's a trademarkable term, but it's a term that you use. And if it's a special script or got a picture or some kind of image with it, it could be trademarkable. Well, somebody else could say, hey, Debbie's been really successful with your career. I'm going to call my show your career. So how do you protect that? Because you want that to be, your career to be only a Debbie thing.
Right.
So that's what a trademark, that's where a trademark comes into place. Copyright is more like copywriting the written materials. And you can do that. You can copyright manuals, instruction books. So you're in the consulting business.
Sure.
And I would think that a lot of your materials that you hand out to your clients has a copyright stamp on them. And that's relatively inexpensive and easy to do. I don't know if you do it on your own, but you go online to the Patent and Trademark Office, you fill out the form, and you first read their information and do your best to complete it properly. Copyright's a little bit easier than trademark, because trademark, you have to also pick out the industries and stuff that you're going to be in. And I'm not an expert on either of these areas. Our firm is, I am not.
Right.
But you want to protect that image. So if you have a special image, you have to do it. When I go to trade shows, I walk around the booths and I look at them and see which ones have special logos, and I'll say, have you registered that as a trademark?
Right.
And most of the times they have not.
No.
But if you're going to be the next Coke or the next Apple or the next Pepsi or the next Microsoft, you have to trademark those terms so that you control them. McDonald's is probably the greatest example we have. You can't most McDonald's aren't owned by McDonald's corporations, they're franchises.
Right.
But every McDonald's has somewhere on their property the Golden Arches, and they have the McDonald's name. That all belongs to McDonald's. And in fact, McDonald's they originally got the name from the McDonald brothers who created McDonald's. And they later were able to stop the McDonald brothers from using their own name because it tended to create confusion. And that's what the trademark is, to avoid confusion, misunderstanding, misleading the public as to the Debbie product that she does is no different than the product that Ed does. And well, it's hard to believe your product may be better than mine, Debbie.
I know.
I personally have a hard time believing that, but it's a possibility. So that's what trademark is all about. Copyright is protecting your valuable writings, and patents are protecting your valuable inventions. Now, not everybody patents stuff. There's also something called a trade secret that's just a secret, and you don't share it or tell it to anybody. Coca-Cola, for example,
go ahead,
is a trade secret.
That's what I wondered.
That formula has never, to my knowledge, has never been patented, but it's obviously closely protected, and they've been very successful, and I'm sure they've got very serious agreements with anyone that knows it. And then I've been told that no one knows the whole formula. They have like 10 people that work over in that department, and each one knows a part of it. I don't know if that's true, folklore.
Yeah.
But I do know that it's not a patented formula, because once it's patented, first of all, you patent the process, or you have to provide this description of it, so somebody could look at it and copy it, and maybe make a poor imitation of it. And second of all, patents only last for so long, where trade secrets last as long as you can keep it a secret.
Yeah. So. Excellent. That's good to know. So really, if we were talking to somebody that's manufacturing a product, then they more than likely would want to be directed to talk to somebody about maybe a patent of a process, or would it be a copyright? I mean, or maybe it's a trade secret, as you mentioned.
Well, like I said, I can't speak with expertise on those issues, but the products itself may be manufactured for somebody else. They may require their logos on it.
Okay.
But you can have your own logo on the, maybe able to have, you want to negotiate to have your own logo on the product in addition to somebody else's. Like if you open up an Apple computer, you're going to find all kinds of parts inside of it, or any computer. With different labels on it. So you want to put those labels on it so people say, oh, it's an Intel chip, so I know it's a super good chip. It's not an AMD chip. I'm just picking names. I don't know if there's any quality difference, but there's some people that only want Intel chips in their computers. There's some people that only want AMD chips in their computers. And there's some people that don't care if they have a completely different third-party chip in their computer. So they open it up and they see what they've got in there. So that brand recognition builds up your reputation, and the more strong your reputation is, the more you're going to sell and the higher price you can get. Of course, you could just lose your trademark like Xerox because everything is a Xerox. And that sometimes becomes into common usage. So there's a lot of issues, but protecting your intellectual property is the key element of any small business. If you want to grow big, if you're just going to be small mom and pop shop, that's all you ever want to be, and you aren't worried about people taking your ideas, doesn't matter. But if your goal is, I want to be the next Coke, then from day one, you need to think, how do I protect my confidential business information? Those are the agreements I talked about. And two is, how do I protect my reputation and identity? Because that's what business is all about.
Yeah, that's great. But the other side of that equation is I want to make certain that when I'm starting a business that I research the name, that I research the logo to make certain that I'm not violating somebody else's trademark or copyright.
And that's something our firm can do. If you bring that in, and not all firms are not all terms and not all images are trademarkable. So for what it's going to cost you to hire a patent attorney or a copyright attorney, and our IP attorneys are all three things, and get those searches done, then it gives you a degree of confidence that you've got a unique thing. And that's important for two reasons. One, you can register it. And two, the likelihood of somebody else being confused with your product is less. So it does pay off. A few dollars or a few $100s spent early on can save tons of money later on. And there are cases where people are ordered to quit using certain logos or representations. And then you've built your company around it and it's gone.
Right. I know I've been surprised in my industry that sometimes even phrases have been trademarked. That somebody in their writing, they not only copyright their material, whether it's a game, whether it's an actual manual, training manual that they're selling, an assessment tool, but the phrases that they have used, that they coined.
For example, you deserve a break today. You know who I'm talking about. Everyone out there listening knows who I'm talking about. That's McDonald's. I haven't looked at it for ages, but I'm willing to bet you if you see it in print, you'll see a TM on it.
I bet you would.
Because that's a key phrase that they've built their business around. So it can be any kind of phrase. If you've got something that you like that represents what you're going to do, protect it. The few dollars it's going to cost you to protect it is a lot cheaper than the large amount of money you're going to spend to try and knock other people out.
Absolutely.
And register it, excuse me, you have to register it federally. There are state trademark and copyright, no patents. But you really want to register with the federal government so it protects it around the country.
Well, that's a smart idea. I hadn't thought about that, distinguishing that. Let's talk a little bit, we've got about 5 minutes remaining, and I'm just curious, let's talk a little bit about contracts. Small businesses are always getting into contracts, and you mentioned this a little bit at the beginning, just in a global kind of way, and I'm curious, when you're reviewing a contract, what are some of the things that you're looking for?
Well, you know, it varies so much from contract to contract and from industry to industry.
Any general examples?
Yeah, for example, if you're selling something or providing a service and you're in Brevard County, you should have a provision in there that says if there's a lawsuit about this, that lawsuit takes place in Brevard County, Florida, or the federal courts supporting it.
Okay.
Because that means they have to fight you here on your home ground. Otherwise, you can be in Duluth, Minnesota. And when you sign contracts, take a look and see what it says so you at least know, hey, I can't sue here in Brevard, I got to go to Duluth. In construction contracts, they can't require you to be out of state. But in all other contracts, they can. You want to consider a provision that if there's a lawsuit, the prevailing party gets attorney's fees. There's differences of opinion on it. One side is that people are more likely to sue if they think they can recover their attorney's fees. The other part is you're going to be reluctant to sue unless you can recover your attorney's fees. So it's okay, and you're not going to sue unless you're right. So it doesn't matter if the other party can get them too. But those are two things that I look for. And a lot of it else is product specific, indemnification. What happens if somebody gets, you're buying somebody's product and passing it through, who's responsible. It's really, really hard to list all of the things. But what I like to say is that contract, what a contract really is a risk management tool.
Okay.
Because you're going to sell your service to me. And you know in your services, there's certain risks.
Right.
One of which could be that you, doing your job, slip and fall on my property and injure one of my people. So who's responsible for that slip? You're on my property, but you're responsible for the slip and fall. So are you responsible for indemnifying the party you have the contract with? If it's a big corporation, you will be.
Yes, absolutely,
they're pretty
you will
harsh
be.
terms, and you can't negotiate it. But also keep in mind, read the contract. That's the single biggest problem. I find people don't read the contracts until they get into a problem. Read the contract and don't be afraid to ask for changes. Sometimes you can get them, sometimes you can't. But many times you can. And then also, depending on the bargaining power of the two parties, if they really, really need you, then they're going to give you better terms. I had a great case years ago where I was working on a contract with this one lady and some software company, and she just didn't want to agree to their terms. She wanted them to agree to her terms. And she walked away from what I thought was a fairly substantial opportunity. I saw her years later, and I said, how'd that ever work out? And she goes, oh, they called me back and gave me everything I wanted on my terms. But she had a particular skill that they felt they needed to make whatever they were doing, and I don't know what they were doing, to make whatever they were doing a viable product. And they would, so there's always room to negotiate. And to me, a refusal to negotiate is usually, to me, a danger sign. Or explain why.
Absolutely.
And then also be reasonable. I had a contract one time with a client that was trying to do a large, was going to get some space, I think, in Lowe's or Home Depot, I don't remember which. And it was a really onerous contract. But there were a few things in there that were particularly onerous and damaging potentially to our client. A lot of the stuff was damaging, but a couple of things that were really of key concern. So all we did when we proposed changes was focus on those few little areas we wanted, because we thought I thought, if we came in and asked for everything, they just say, we don't need we don't need your product. So we focused on those areas which had to do with intellectual property rights, marketing materials, and stuff like that, because Lowe's would have owned it the way it was written. And they cooperated with us and let us keep some of the stuff that we thought that we would have had to give up in a reform contract. After you sign the contract, read it again and make an outline of your rights and responsibilities, make an outline of their rights and responsibilities.
Good point.
And every time you have a transaction, goods or services passed between the two of you, something that's going to bring you money. Take a look and make sure that both sides lived up to their responsibilities. And don't do anything extra for free.
Perfect.
A lot of people do.
You're right, because scope creep really gets into there, and people aren't paying attention to it. They're just trying to take care of the client.
The beginning of a contract everybody's happy and smiling, and everyone's going to make money, and all things are going to be done on time. Well, at the end of the contract, getting done on time and within budget is more the exception, in my experience, than the rule.
Wow.
So in that honeymoon phase, you need to be rigid. Good contractors win. So you need to be rigid in that honeymoon phase and say, okay, if there's a change, something's different, I'm going to do it. I'm not just going to eat this $10 or eat this 2 days. I'm going to stick with it, because when you get to the end, all the money is squared away. You might have arguments at the front, but you're all arguing about what the contract terms are.
Right.
And in the end, the closeout's going to be a lot smoother. And they will come to respect you over the course. And as a final bit of advice is never argue about what a contract says without looking at the contract. You can diffuse, a lot of people think they know what it says, they think they remember what it says, and then start, I'm sure you've had problems like this with your customers say, well, your contract says you have to do this. You say, no, it doesn't. Well, instead of saying, no, it doesn't, say, I don't recall that being in my contract. Why don't we pull out the contract, step back to your office, pull out the contract, and look at it.
Yeah.
And if you're right, I'll do it. And if you're wrong, we'll figure out how we can do it with minimal of disruption.
Much more reasonable approach. That's going to be the last word. Thank you so much, Ed. Wealth of information. We could go on another hour, I bet.
No,
this is
I'm
great.
tired.
Well, thank you. Well, on behalf of my guest and everyone here on the set of Your Career, thank you for watching, and remember, be career happy.
More information about this program is available online at millermediagroup.org.